have to buy anything. You don't have to be the victim of a data breach. All you have to do is find a website that, is set up in a way that there is not consent for all of the third-party technology that is being deployed, and you have a claim. Oftentimes, with a mandatory arbitration clause comes a class action waiver. The plaintiff then knows, and the plaintiff's lawyer then knows, they can just absolutely bury the business in fees until they settle.
Hello everyone, I'm Sergio Maldonado and this is Masters of Privacy, a set of interviews covering the intersection of marketing, data, privacy and technology with a clear goal in mind, which is redefining the relationship between people, brands and media around transparency and control. Which is to say, we're aiming for real customer centricity, or if you will, human centricity. We regularly talk to DPOs, CMOs, CDOs, and whoever else we find interesting and able to share valuable insights. So we hope you like it. Please do reach out if you have any ideas on future topics or speakers. Okay, we're now starting a new season of Masters of Privacy, which has been running for nearly 6 years, originally in Spain and the UK, and for the past 2 years recording from the US. As a novelty, this season we're introducing regular meetups, mostly in person and mostly across multiple locations in the US, starting with a breakfast workshop in San Diego, California on September 22nd, with a good healthy breakfast on Mission Beach, always dealing with topics that combine MarTech, AdTech, and privacy. And then a live newsroom recording in New York City on November the 6th. And that is an evening gathering with drinks and some snacks. You will find more about them and how to attend on mastersofprivacy.com. Now let's move on. Our guest today is Jennifer Oliver, an experienced commercial litigator who has defended consumer class actions and multi-district litigation, including those arising from data breaches and antitrust. She has worked in several high-profile jury trials, serving as lead counsel in complex mediations. She also counsels clients on matters related to privacy compliance and use of AdTech and similar technologies. Jennifer is a shareholder at Buchanan, the law firm, and has a long list of relevant affiliations and certifications, including being an executive committee member of the privacy section at the California Lawyers Association. With Jennifer, we've dived deeper into AdTech or pixel-related litigation in California, both in court and through arbitration. Let's go for it. Jennifer, thanks for joining me.
Thank you for having me.
It's a pleasure. So I'm excited about discussing litigation. We haven't done it before. So what are the most common avenues for people to get into litigation in California if we talk about privacy or data protection, please?
Yeah. Yes. So, for a long time, I think the most common avenue for a defendant to be the subject of privacy litigation in California was considered to be a claim under the CCPA. So, a data breach or the like. And I think that was sort of well understood by companies that, if they had a data breach, they would very likely be subject to some private cause of action under the CCPA. CCPA and common law related to that breach. But about, I would say 2 or 3 years ago, we started seeing a new trend in privacy litigation, especially in California, but in a few other states as well, related to technology and especially third-party advertising technology being deployed on websites, and especially consumer-facing websites, healthcare websites, retail websites, etc. And that was sort of a new theory because typically those claims were not under the CCPA, but rather under an older California statute called the California Invasion of Privacy Act, or CIPA, or some people say CIPA. I think that's still up for debate, but CIPA. And those claims, our plaintiffs bar in California is very entrepreneurial and creative. And because the private right of action under CCPA is relatively narrow, they found a way under CIPA to bring causes of action for website technology, even though CIPA, was passed long before the advent of the internet. And what CIPA regulates is more or less, it's a penal code, and it regulates wiretapping and the use of pen register and trap and trace devices by law enforcement. And so plaintiffs' lawyers said, hey, couldn't it be that the new way that we communicate is more not over the telephone anymore, but over the internet? And couldn't it be that communications that take place over a website could also be wiretapped and could also be a violation of CIPA if the other party doesn't realize, if the website user doesn't realize that their communications are being heard or transmitted to a third party? And so that they experimented with that theory of liability several years back. Some of our California courts and judges said, yeah, I think you might have something there. You could possibly state a cause of action there. And then it was just sort of off to the races, and we saw just hundreds of these claims. Yeah.
Yeah. So we touched that in passing, I have to say, we in a couple of interviews, not specifically about CIPA, but we touched on it because of that reform and so on, upcoming reform. Mm-hmm. But so what's the primary motivation? Is it just making money?
Well, it's a good question. If you asked plaintiffs in the plaintiffs bar, I think, their answer would be that private plaintiffs and plaintiffs lawyers in the privacy bar in California consider themselves, and by the way, I have worked on both the plaintiffs and defense side, but consider themselves to be private enforcers of the law. So the thinking is that the California AG and regulatory entities cannot on their own enforce these laws fully. And so, there's a reason there's a private right of action under certain of these laws, and that is because there was a legislative intent to allow private individuals to enforce the laws, and it has a deterrent effect. Certainly, though, it is a very good money-making endeavor for the plaintiffs and plaintiffs' attorneys because there are statutory damages under CIPA and CPPA as well. The liability and the exposure is quite significant when you look at it as a class action. So one individual violation might only be worth $5,000, but when you multiply that by every person who's visited your website in the last year, you can see how that would very quickly become quite concerning for a defendant. So the settlements can be rather significant. There's a huge volume of settlements because it's very easy to find a plaintiff to bring a claim. All you have to do is go to the website. You don't have to buy anything. You don't have to be the victim of a data breach. All you have to do is find a website that is set up in a way that there is not consent for all of the third-party technology that is being deployed, and you have a claim. So low barrier to entry and high return on the investment.
So some people see that as a public service. This has to be enforced. The AG cannot cope. So pretty much like Max Schrems and OIB do in the EU, except that there is money to be made.
There is money to be made. And we don't actually see the AG enforcing CIPA in this way. It is mostly private plaintiffs. But, I think they would also say, look, these lawsuits have changed the way that companies do business. And I think that's actually probably true because the proliferation of cookie banners and consent banners and opt-in consent in the US in recent years, I think is at least partially attributable to these lawsuits.
So that means that even though we've got an opt-out world in the case of do not sell share with CCPA, that now because of these things, people are forced to imitate, to replicate, to do the same thing that we do and that we hate in Europe, which is that you have an opt-in.
Right.
So now you've got this blend, and
Yes.
that's not only California businesses, because if you are serving California residents, then you're already subject to it, right?
Right. So yes, I think you're right. These lawsuits have caused many businesses to change to an opt-in model, and you're also right that businesses hate it, and especially the marketing teams hate it. This is a big push and pull between legal and marketing. Legal is saying if you don't want to incur a risk, you need to go to opt-in. Legal is saying if we go to opt-in, it's going to destroy the volume and quality of data that we're getting. This data is very valuable. So there is sort of a business decision to be made there. Some businesses, I think, are willing to say this is not a clear violation of the law, and we are willing to incur some litigation risk and pay one or two small settlements a year in exchange for not using opt-in and continuing with opt-out or with no consent banner at all because this data is very valuable. So that is a business decision there, and that's what's really frustrating, I think, for the businesses is, you make an effort and invest time and money to comply with CCPA. You have your do not sell and share. You think you're all set. You've consulted with counsel, and then you get this lawsuit and you say, no, this is wrong. We're compliant. And then the answer is, well, you're compliant with CCPA, but this is something different. And, it's a little bit of a gray area. That's very frustrating.
Really annoying. Okay.
Yes.
Okay. Good. So more avenues then. So then you may have, so what happens with arbitration, please?
So arbitration, if a website owner has a mandatory arbitration clause in their terms and conditions, then we also see these demands being filed in private arbitration. And oftentimes with a mandatory arbitration clause comes a class action waiver, which, for probably obvious reasons is very valuable to the business. They don't have to be sued in court. They don't have to face a class action. There's a reason they put these terms and conditions on the website. And so you get an arbitration. It could go one of two ways. You get an arbitration demand from a consumer and you deal with it individually, or the consumer files in court anyway, and then you have to enforce your arbitration clause, which is sort of an interim. So we see certain plaintiffs' attorneys who like to be in arbitration. It's kind of under the radar. They can file a lot of claims there, and sort of do a high volume business in arbitration. And then other plaintiffs' attorneys who are known to file in court, even if there's an arbitration clause, and make you try to enforce it. And it's unfortunately not always enforceable. If it's buried in a link at the bottom of the page and there's no explicit consumer consent to the arbitration clause, you may not be able to enforce it and end up in court anyway. So that's sort of an interim issue that clients don't realize.
That's super interesting.
Yeah. The website owners just think, I put this in my terms and conditions, I'm all set. And the consumer says, who goes to a website? And I think this is a fair point. Who goes to a website, scrolls down to the bottom and reads all the terms and conditions before they proceed? That's just the reality. Nobody does that. And they say, I didn't consent to that and you didn't adequately disclose it to me. And so another best practice is, in addition to your cookie banner, that's getting consent for your technology. You want to get consent for your terms and conditions and privacy policy so that you can enforce those if you need to. I don't know if that quite answered your question, what happens in arbitration, but I wanted to cover before you get to arbitration, don't assume you're going to get to arbitration just because you put it in your terms.
That's really interesting. I remember the years with shrink wrap agreements.
Exactly.
When you would open the software and then click wrap agreements or
Exactly.
browse wrap agreements. So this idea.
Yep.
So, and from a European perspective, because there's more consumer protection, and there's different layers of consumer protection. And then we always assume that many of these clauses are just going to be considered abusive because nobody could really negotiate and they're imposed, so it's very hard to make them, to enforce them. But I always thought that you would have more leeway in the US with these things. So it seems like it depends on the court, right?
I think probably in some states more than others. I mean, generally, there's a strong deference towards arbitration in any venue. But in California, I can tell you, I have seen these motions to enforce arbitration clause. And if there's no evidence of consent, more often than not, they're not successful. So you do need to, you can enforce that arbitration clause. You can force that consumer into private arbitration, which maybe in Europe you wouldn't even be able to do with consent because it is sort of a take it or leave it proposition. You either agree to arbitration or you can't come to the site. But you have to actually agree, at least in California. So
great, thank you. Then is arbitration always a winning strategy?
there's a feeling among, I think, website owners that if I can enforce my arbitration clause and class action waiver, that's going to be great. It's going to be a huge time savings for me. I'm going to save money. I'm not going to be in a class action in court. These individual plaintiffs are not going to want to litigate with me over $5,000. This is a great tool to head off these claims. And that's not necessarily true because the plaintiffs bar, it has become very effective at ramping up mass arbitrations. So they will put out advertising, social media, elsewhere. If you have visited such and such website, you may have a claim, call us, and they will file dozens of individual arbitrations that have to be heard before separate arbitrators and for which the business pays almost all of the fees. So it can be $3,000 in fees paid by the business for a $5,000 claim, where the claimant only has to pay $300 in fees. So the plaintiff then knows, and the plaintiff's lawyer then knows, they can just absolutely bury the business in fees until they settle. So that's something I think that's really important to be aware of in litigation strategy. If you force consumers to arbitrate, you don't necessarily have an upper hand. And in fact, they may have an upper hand because the fees are so lopsided in consumer arbitrations. Again, to your point, to make it fair for the consumer. If you're going to force a consumer to arbitrate, you can't force them to pay more fees than they would have to pay in court. So the fees are very low.
Okay, so then moving on into common law and these invasion of privacy, things that have been around for a long time, do you see a lot of them?
I see those claims usually not standing on their own, but as sort of add-on claims to the SIPA claims. So we usually see in the AdTech cases a SIPA, a Section 631 claim, which is a claim that the website user aided and abetted a third party. So that would be Meta or Twitter or LinkedIn or another third-party advertising platform or analytics platform, that the website user aided and abetted that third party in eavesdropping on the conversation between the website user and the website owner. So that's probably the most common claim, although more and more prevalent now is the SIPA 638.51 claim, which is the trap and trace provision of SIPA. And that law says it regulates, well, traditionally regulated law enforcement's use of pen registers and trap and trace devices to tap telephone lines, but has now been interpreted by the plaintiff's bar to apply to technologies on websites that capture IP addresses and other identifying information. And they have taken the creative position that those can constitute trap and trace devices. So those are the two most common claims that we see because they have statutory damages. And then as add-ons, sometimes we see invasion of privacy, intrusion upon seclusion, and violation of the constitutional right to privacy, all these other add-on claims. More often than not, those causes of action, regardless of the state, require a really egregious invasion of someone's usually personal space. They're meant for people peering through windows and, stealing private documents and things like that. And so it's hard to really argue that the fact that you were browsing for shoes and then got an ad in your Facebook feed is an egregious invasion of your privacy. So they don't really tend to succeed. I think they just kind of throw in as much as they can, and those claims tend to be dismissed or fall by the wayside when you actually get to litigating.
Okay. Is there anything that you wish your customers had done differently as you are about to face, or they are about to face litigation? Bearing in mind that many of their tools come with bundled built-in pixels like Shopify with the Meta pixels or WordPress with analytics tags. Would gathering consent have been a silver bullet? For example, when you look back at the data collection stage.
Yes, it's a great question. And, I wouldn't necessarily just say, oh, I just wish that you had a consent banner and got consent, because again, that's a business decision and it may not be right for everyone. But I think my answer would be to have educated themselves on, first of all, what technology is on the site. Oftentimes we talk to website owners who don't even realize what's firing on the site for a number of reasons. Either there's not good communication with the web and marketing team, and the web and marketing team is trying to do their job as best they can, and they're putting all these things on, not thinking that there's reason to talk about legal implications, but also because of, to your point, integrations and not understanding when you are working with Shopify or other third-party platforms, what is running by default, and oftentimes you can control those pixels. And so educating yourself, first of all, to what's firing on the site, just like doing data mapping and understanding the data that you collect, where it's being stored, how long it's being maintained, who can access it. It's the same concept. Understand what's on your site, when it is firing, where it's sharing information. I talk to clients all the time who get these demands and say, I'm not sharing any information with any third parties. Well, they are, but they didn't realize it. So really understand what's on the site and then understand your risks and options so that you can make an educated decision about whether you need or want a consent banner, or maybe you just need or want a consent banner only for IP addresses in California. There's a whole decision tree, but you need to know that you need to make those decisions, and ideally before you get a litigation demand, which is when we're seeing a lot of people then start to make those decisions and mitigate, is after the litigation demand. I guess that would go back to, as much as I hate to do it, supporting my colleagues in the plaintiffs bar saying, we're effectuating change here.
I'm sure you're not going to get bored. That's what it looks. That's what it seems. But what do you think will be coming next? If SIPA lawsuits disappear in a few months, for example, something was just discovered, which was that Meta was doing some additional fingerprinting on Android phones because they could connect identifiers on Instagram apps to websites that you visit on your mobile phone, on Android at this point. And that had never been discovered, never been used. So I don't know, there could be so many things still to unveil in terms of practices. But that's the technical side. How do you see things playing out in the future in terms of your job?
So you're right. There is legislation that has broad bipartisan support, although it's only in California, to amend SIPA to carve out these types of technologies. In my experience, that will be only a temporary setback for the plaintiff's bar. I think tracking technologies and advertising technologies and third-party advertising platforms, collection and use of data, and tracking of people on third-party websites will continue to be a source of litigation. They'll just have to find another way to bring those claims, whether it's common law or amending the CCPA or finding another ancient statute that they can interpret. I think this is the direction that we're going, and it will continue with or without SIPA. They'll just have to find another way.
Jennifer, thank you very much.
Thank you so much for having me. This was fun.
Okay, that's all for today. You will find additional information about today's interview, the topics we've covered, and related prior episodes on mastersofprivacy.com. If you want to dive a little deeper into this particular interplay between privacy or data protection law and marketing, e-commerce, or media, you can also join the Masters of Privacy Connect program. Hopefully, not to get more emails, but rather to get into our workshops and live sessions at no cost, as well as to gain exclusive access to some tools, ideas, summaries, or training materials that we believe can make your life easier. This program is available as a Substack subscription for now, but I would also like to encourage you to join our LinkedIn group or follow our Blue Sky feed if those are the platforms you prefer. Thank you for listening.